will then proceed to give the floor to Honorable Ewa Bafo.
Thank you, Mr. Chair. The tempo has been a bit up, so let me bring it down. Congratulations, my Lord. My Lord, from your CV and your own account, before joining the bench, you practiced as a lawyer from Holy Trinity Chambers. Can you please, by way of clarification or information, let us know whether it's a partnership or a limited liability company or a company on limited by shares?
Thank you, Chair. Chair, in Ghana, you can register a company, a law firm, as either sole proprietorship, unlimited liability, or partnership.
My Lord, I want to know whether Holy Trinity, what is its legal
sole proprietorship?
What do you want?
Legal consult of Holy Trinity Chambers. Why we do not allow companies to be registered in Ghana as a limited liability is that once you own a firm, your liability is unlimited. Because if you dupe somebody, you use fraudulent means to take money from your client, and you say that it is limited to my shares. No, it is limited to your own properties. That is why no country allows a company to be, a law firm to be registered as a limited liability. It can be unlimited, partnership, or sole proprietorship. So Holy Trinity was sole proprietorship.
Now to my substantive question. I wanted information.
You don't have a preliminary question and a substantive question, so you can either ask a follow-up.
Mr. Chair, very respectfully, the basis for my question was the reason why I sought clarification.
Honorable member, you are entitled to one question. You have asked the one question. So if you don't have a follow-up, let me give the floor to another person.
What do you make of a lawyer who maintains an interest in a firm after he has joined the bench? What do you make of it? Is it appropriate?
Honorable member, this cannot be a follow-up question. The question is accordingly overruled. I will then proceed to give the floor to Honorable Akurugu.
Thank you, Mr. Chair. Congratulations, my Lord. Yes, your students you've taught before speak highly of you, your human relation, and your command over the law. And you make law so easy. And I think based on that, I had an encounter with you, and I was contemplating going to read law. But there is this issue concerning about expanding access by breaking the monopoly of Ghana School of Law in the training of lawyers. Do you agree to this suggestion, and what reforms would you suggest for the legal education in Ghana? With regards to Makola, you go to do your LLB, then Makola. So, thank you.
Thank you very much. Yes, my Lord.
Thank you very much.
Your answer.
The legal education in Ghana is confronted with multiples of issues. Initially, we had it only at Makola, but we had emerging universities. So the students were not getting admissions. Then it was decided that we should have 2 campuses. Then we have Gimpa and Kumasi. Still, there is an issue. We have an issue. The issue about admission, even though last year the law school tried to admit about 1,400 students, but how many students are turned out from the universities every year? We used to have only 3, 4, 5 universities, and now we have about 13, including those who do theirs outside the country. So at the end of the day, if you look at those who sit for the entrance exam, you may get about 3,000, 4,000, and the school can take only about maximum 1,400 students. So here, there could be a policy decision. The policy decision that I read online was that why don't we allow some of the schools to do the bar, and we use the law school as we use the law school as examination center, accreditation, monitoring, and evaluation, and other departments to ensure that the integrity of legal education is not compromised. So we can have it. We can have, because it is a policy decision, and as a judge, I don't want to delve into policies. But what I will say is that if the most important thing is that if feasible studies have been done and it has revealed that this one is better than what we have now, there is nothing wrong. I will only have an issue with it where there is no feasible studies, where there's no feasibility studies, and we are just jumping the gun. But where we are satisfied that we have examined this, and this is the better option, we should go for it. Thank you.
Any further question?
Mr. Chair, no further questions. Congratulations once again.
Thank you. I will then proceed to give the floor to Honorable Anthony Imie.
Thank you, Mr. Chairman. Congratulations, nominee, on your elevation. You're almost there, if you pass the test. Now, let's look at
and you do it on social media. If you do it in the country physically, it is an offense. And therefore, if you do it on social media and it is an offense, it is not an extension of anything. Assuming it is not an offense if it is done within the jurisdiction, and you do it on social media, and we are criminalizing it, that one, it will be wrong. But if you do it in Ghana, physically, it is an offense. So wherever you do it, it should be an offense.
Any further question?
Thank you very much. My next question. My Lord, recent surveys by Afrobarometer, Global Corruption Barometer, Ghana Integrity Initiative, etc., suggests a decline in public confidence in the judiciary. What specific reforms would you propose to restore trust in the judiciary?
Thank you, Chair.
Yes, Honorable Nominee.
Chair, when I was the Director of Judicial Training, we decided to make ethics a component of whatever training that we give, either to the judiciary, the judicial officers or staff. The reason is that when we are talking about corruption, we are talking about something which is bad, then we must make it a conscious effort to fight it. If you do not fight it, it will become endemic. And therefore, the most important thing is that we need to first and foremost conscientize ourselves about the effect of corruption. Then the second one, what do we do to curb it? We need education. We need training. Then one thing that people of Ghana that you don't do is that if a public officer, either me or any other person, demands money from you, you must report the person. You will condone. You will give it. Then when it comes to assessment, you say that you will not mention the name. Then say that the whole judiciary is corrupt. That is the problem, and it is about perception. And I can talk about personal experience as a director of the Judicial Training School. On one occasion, I was training. Then somebody came to me to complain about somebody who was taking money from him. We we made the inquiries. I was then the director of the public complaints unit of the Judicial Service. We investigated. The person who allegedly took the money from that person entered the courtroom and bowed to the judge. The judge did not know him. Just to give it a semblance that he had given the money to the judge and was coming to bow to show that the person who is accompanying him is the person who gave out the money to him. But it was false. So these are some of the things that we do and we must stop. In most cases, if you listen to some of the TV discussions, social media, you know, instead of bolstering the faith of people in the judiciary, we are rather saying that the judiciary is corrupt. But if you ask for evidence, then we say it is perception. So the most important thing is that we must be bold. If we have physical evidence, we must use to substantiate. Otherwise, we shall be talking about perception, because any person who goes to court and loses, the person's position is that because he did not pay bribe, he or she has lost. But it is not the matter. The case is bad. So apart from training, we need to conscientize ourselves. Then the third antidote is that if a public officer corrupts himself, that person must be prosecuted. Thank you.
Now my last question. In your view, how should the Ghana legal system evolve to address matters like climate change, environmental degradation, resource extraction? Let's take into consideration the current issues related to Galamsey, which has been ongoing for some time now. How should our system evolve to nip all these menaces in the bud?
Thank you, Honorable Chair. Honorable Chair, we talk about judiciary, and the judiciary, we are moving from the traditional judiciary to the modern judiciary. Now, Judicial Training Institute, we teach environmental law for judges to equip their capacities. Unfortunately, most of them do environmental law at the faculty. Law school is not done. But when they come to the judiciary, the initial training, it has been incorporated, the induction, as part of the system. Then in addition to that, we have continuous judicial education. And these are the things that we introduce to the judges. And was it 4 years ago, there was a case in Takwa where the judges was accused that the judge, somebody was involved in illegal mining. It was brought before the judge. The judge sentenced the person to 6 months. I called for the docket on behalf of the Chief Justice. I was then the director of the Judicial Training School. When it came, the police did not prefer mining offense. They preferred, the charge was trespass. So if you haven't seen it, you may believe that the person has committed offense under the Mineral and Mining Act, and the minimum sentence ranges from 5. Meanwhile, the police who arrested that person prepared a charge of trespass. So we need to build the capacity of the judges. And when I was the chairman for the African Judicial Network on environmental law, I made sure that the selected countries, the pilot countries, Ghana was one of them. So they gave Ghana, is it about $60,000 or so, judiciary, to have a manual to train on environmental law. And I made sure that the contract was awarded to a Ghanaian. He was Mr. Asumda. He used to be the dean of Zenith. I don't know whether he's there or not. And he prepared it, we validated it, and it became the property of the Judicial Service. So these are the things that we need, because environmental degradation, air pollution, sea pollution, illegal mining, if you do not fight, it will fight us. Because, so what I will conclude is that, yes, we need to build the capacities of the judges as well as lawyers, so that when we get cases involving those matters, we will not fall short. We will do justice to what the law says. Thank you, Mr. Chair.
Now my last follow-up question. How would you balance swift environmental protection through deportation against due process rights in criminal law?
Honorable Chair, I will use my position as the chairperson of the African Judicial Network on environmental law. We use the two together. It is a tool that you need the two. You must take drastic decisions in environmental law, at the same time pursue criminal charges against them. Because if you do one to the advantage of the other, that means those who are not within the net, they will not be caught. So ideally, we need the two to fight. It is not an alternate, it is joint. Thank you.
Thank you very much. I'll proceed to give the floor to Honorable Alhaji Omar. Honorable, you have the floor.
Thank you, Chairman. Sir Dennis, congratulations, my Lord. I want us to talk about this House, Parliament. Of late, we've been having some challenges about the privileges and immunities. And I would like you to tell this committee how best, or what are the privileges and immunities, and how best can we safeguard it. Thank you.
Thank you. Parliament is likely to lose its existence if it loses its privileges and immunities. The privileges are the additional rights that are given to members of Parliament to enable them to function. That is, they must be bold and they must hold government accountable. But if the privilege is not given, or the immunity, they are not immune from acts such as being arrested. We have said that at Parliament, you have said something, then you are hunted for, you are arrested. Then that means the whole immunity is gone. You are immune from some of the laws that ordinarily would have constituted crime, but you are immune, crime or civil wrong, but you are immune from that one. Honorable Chair, let me give you an example. In 1215 AD, when the Magna Carta was signed by the dames, the barons, on the other hand, and John the King, it was 1215 AD, meaning we are ending rule by law, we are moving to rule of law. Now, when they moved, and Parliament insisted that they needed immunity, the monarch said, we will not give you immunity, otherwise we'll be at par. And they fought for 474 years until 1644, when the English Civil War. The English Civil War was brought about the rift between Parliament and the monarch. Monarch was eroding Parliament of its privileges and immunities. That was why they fought. And fortunately, Parliament was able to overpower the monarch and overthrow monarch. That was where Cromwell became the president. They changed from monarchy to republican. And when Cromwell died, his son, Richard, took over. Richard was also messing up. Then they went back, that we should go back to the monarchy. And the monarchy, they brought in James II. What happened? When James assumed power, James said, Parliament will not allow you to exercise freedom of expression. Closed book doctrine will not allow you. We shall interfere. You know, it brought about another war. And that war, James ran away. And that brought about the first time that we had a male and female monarch coming together. That is Mary II and William III. When they came together, then they were forced to sign the Bill of Rights of 1879. And when it was signed, that was where it said that Parliament, you have immunity. You can have closed book. When you have matters before you, the court cannot come in. The court will come in after you have decided and the outcome offends any law. Then when you go to Parliament, you have you have absolute privilege in terms of what you discuss and what you say and what you debate, unless you are stopped by the speaker and you fail. Then that one, the speaker may deprive you of your immunity. Then they said that if you are, if you are talking about parliament, it should not be limited to only Parliament House. Parliamentarians attending committee meetings or any meeting initiated by Parliament. That was how all these things came about. So now, all these things came about, and the Parliament in UK is the strongest in the world. And if the law, the Constitution has given it to us, and we do not defend it jealously, then a time may come that Parliament may lose its relevance. We must guard jealously against the executive and judiciary encroaching into your closed doors business. Then a time may come, you cannot even argue, because they will come and tell us what is going on. Thank you.
Thank you, my Lord. And we will guide it jealously.
Any further questions?
Yes, I have one. I have one more. There have been two. Thank you so much for the education, anyway. Second question. There have been two conflicting decisions of the Supreme Court in respect of its enforcement and interpretation. Jurisdiction under Article 2 and 130 of the Constitution. What is your opinion or position?
Thank you very much. Now, unfortunately, it has come to an end, but let me state it. The Supreme Court had two conflicting petitions, but in law, when we talk about enforcement of Constitution, we are saying that identify the law, implement it, that is, identify it and implement and make it applicable. That is what we mean by enforcement. But when we talk about interpretation, we are saying that it is either unclear, ambiguous, and therefore you need interpretation, or the two parties have put on two rival meanings, or the two enactments in conflict. There are two provisions of the Constitution which are in conflict, or the Constitution has set up a body, and the operationalization of that body cannot be done because of the provisions in the Constitution. Now, there was no ambiguity as to the enforcement or the interpretation. But Supreme Court, when it was composed or presided over by one particular judge, then the word or, enforcement or interpretation, the word or remained or. But whenever another presiding judge was on the panel, then the word or became end. According to him, if the word or remain or, then there will be, Supreme Court will be inundated with cases. All cases will come to the Supreme Court. But if you make it enforcement with interpretation, then you cannot come to the Supreme Court only for enforcement. It must be enforcement with interpretation. But the irony was that Osei Boateng versus Ghana Media Commission was where the two heads met. The one proposing end and the one proposing or. Then fortunately, the one proposing end had a majority, and the one proposing or had a minority. And in his dissenting opinion, he said that I perpetually disagree. And fortunately, the one who said end retired. And the next case that came, Call versus Attorney General. So the one who said or was presiding. So he had the majority, and he said that the word or is or. And the Supreme Court went ahead to say that all the decisions that held that the word or should be end had ceased to be good laws and should not be followed. So now it has come to an end, provided another set of people will not come and take it from another angle. Thank you for now.
Thank you, sir, and I wish you well.
Thank you. I'll give the floor to Honorable Patrick Obama.